Hi, everyone. We are right at 1 o'clock, and I know we've got a pretty big crowd expected today, so we will start at 1:01. So just sit tight because we want to make sure as many folks roll in as possible. All right, it is 1:01, and we always leave some stuff out because we never quite move fast enough because we get to talking. So we are going to get started so we can start on time. Welcome to Victims of Crime and the Civil Justice System in California. And I want to call out 2 points of that title, of that headline. First of all, we're going to be discussing specifically California law today. If there are those of you from another state, a lot of this is very general, so it'll still answer quite a few of your questions, but we may not be able to answer state-specific questions. And number two, we have civil justice system with the civil in parentheses. We're going to very briefly touch on both the family law system and the criminal law system, but that will mostly be to draw comparisons to how the civil law system works. But we will, again, discuss very briefly how those other two systems impact victims of crime. Joining me today is our very special guest host, Micah Liberty, Micah Star Liberty. Micah is one of the busiest and most stretched lawyers I know, but stretched in a good way, I think. So I'm going to let Micah go ahead and introduce herself.
At only 5'4", I'm still stretched. Thanks, Renee, so much for having me. It's a real privilege and honor. I'm excited to be here. I have been a lawyer representing victims of sexual abuse, sex harassment, and human sex trafficking for 25 years now. I practice all over the country, and I am a proud board member of the National Crime Victims Bar Association, and I'm pleased to be here to talk about how we do things in California.
Awesome. Thank you, Micah. Okay, before we really get started, a couple of quick housekeeping items. We do always keep the chat open for everybody to jump in and introduce themselves. I know we are a very active, very friendly field, and people do like to chat. So please go ahead and say hi and go ahead and feel free to talk in that. However, I will call that out to say that at NCVC, we only use the Q&A function to address questions. It's just easier for us to keep track that way. So I know we've been doing this since 2020, but just as a reminder, the Q&A function is if you hover over that black bar, sometimes it's at the bottom of your screen. For me, it's at the top. And you look, it'll either be under more with 3 dots and it'll say Q&A. You can go ahead and ask your questions in there. We will be taking questions pretty much as they come, as long as they're topical. If there are ones that I think are better to hold till the end, we will do that. Krista and my team are on. They will be sending you an email at the end of this. That email will include a survey. If you fill out the survey, we will be sending you a certificate of attendance. Otherwise, everybody will be receiving an email with all of the materials, including the video from today, and you are welcome to hold on to that. It will also be on YouTube. We do not do CEUs, but we will be providing certificates of attendance, again, if you complete that survey. And Krista will also drop it in the chat at the very end. So very quickly, this program is being presented by the National Crime Victim Bar Association in conjunction with the National Center for Victims of Crime. Most of you probably know about the National Center. I think that's how you heard about this email. We have quite a few programs that we operate, the important one being the National Crime Victim Bar Association, which you can find at victimbar.org. What that is a professional association of attorneys that help victims seek justice through the civil system. So they are the ones filing lawsuits. We offer civil justice seminars state by state like these to make sure we're training folks on what the civil justice system looks like. And we also have an attorney referral service. So if you go to that victim bar and you drop down and select find an attorney or attorney referral, I review each one of those cases, and we will try to connect you with one of the attorneys within our network. We're going to add a few caveats about that later, but for right now, that is what is important for you to know. And Micah is one of our amazing members of the National Crime Victim Bar Association. And touting her. I think she's one of the best people to present this because she's really what we aim to achieve, which with the bar, which is making sure we have victim-centered, trauma-informed attorneys who are taking these cases. And finally, our last pitch. We hope to see you all in Orlando. That is our National Training Institute. And this year we have a party almost every night, but the big one is in Epcot. We will be treating everybody with fireworks in Paris and a dessert reception. So we definitely hope to see you there. I have to say that is a separate ticket, so everybody knows, but we got some pretty good rates. So with all of that, I always like to start with knowing, and I'm watching some of your responses and hellos come through on the chat. Just introduce yourself so Micah and I kind of know how to tailor this presentation so we know who we're talking to. Put in the chat, how do you serve crime victims? Hopefully everybody's primarily in Los Angeles, but if not, go ahead and put somewhere else. And then what's your experience like with the civil justice system, if you have any? Oh, and if we have any attorneys, because I know we invited some members of the bar to see how these work, but if we have any attorneys, please go ahead and let us know that you're in too. Okay, victim specialists with FBI, victim advocates, lots of victim advocates. We've got somebody from Nigeria. I'm not sure how helpful this will be, but you could at least learn about that. That's fun.
Amazing.
I know. So mostly California, which is always good news. I see a couple of other states, and again, we will try to absolutely help you all out and fill you in on those states with the caveat, we can't speak to their laws directly. All right, so let's go ahead and get started. At the very first outset, I want to address a couple of misconceptions, and these are incredibly important to understand because TV has taught us so many awful things about American law. First of all, everybody has a right to an attorney. That's patently untrue. You only get a right to an attorney if you are in a criminal case and you are the defendant. That is the only time the government has to provide you with an attorney. I like to say you always have a right to have an attorney with you if you can afford one. In some family law cases where child removal is at stake, parents will receive an attorney. The child will receive a guardian ad litem. That is state by state how that works. And there are some cases, and we'll talk a little bit about this in family law, where there's an organization called Legal Services Corporation. They provide no cost attorneys, but you've got to be under the poverty line, and those do not apply for civil suits. So you can only sometimes have an attorney if you can afford one, even though you always have a right to have one with you. There is no real right against self-incrimination. It is not absolute. The only time you can plead the fifth is if you will criminally implicate yourself. So you cannot plead the fifth just because you don't want to talk about something. And that's whether you're a witness, whether you're a party, whatever. You can only say that if you will be criminally implicated. And important to our talks today and what we're going to talk about, we get a lot of emails saying we want to sue this person. There's this misconception that winning a lawsuit guarantees you're going to get a ton of money. We'll talk about why that's not the case, but that's not always the case, and it's why we won't take some cases. And going to court is free. It is very much not free, even beyond court rights. And also, victim expenses are paid by. I'm actually going to open this one up to the participants again. Who do you all think victims' expenses are paid for by?
Oh, are we polling the attendees?
Yeah, add it in the chat. I don't like to poll. I like to get random answers. Because somebody usually gets it right. Nobody wants to talk today. Victims' expenses are paid for by the victims generally. We're going to talk a little bit. There we go. It depends. The victim. Yep, that is correct. It is 100% the victim. We'll talk a little bit about victim compensation. We'll talk a little bit about restitution, but generally, it is very expensive to be a victim of crime. So just setting everybody up, we've got three justice systems that we're going to briefly touch because they do implicate crime victims every day. The criminal justice system, we'll delve a little bit into this more. The civil justice system, which is what our attorneys focus on. And then I'm going to very quickly touch on family court because family court does technically fall under the civil justice system, but we don't practice. You have to be a very specialized family attorney in order to practice. So our attorneys generally do not do that. And here's why it's important. In the family court system, you've got divorce, custody, alimony, and payments. Divorces in most states, but not all, are considered contract law. They fall under contract law. They are no fault divorces. So abuse, infidelity, any allegations of wrongdoing generally don't matter when it comes to divvying up property. And that becomes especially important in abuse cases. We get a lot of domestic violence requests for attorneys. Um, those still have to be handled by a family law attorney because generally, um, you can't sue for domestic abuse and expect to get more of what your marital assets would be, if that makes sense. And then support payments and alimony. Again, even if abuse is alleged, it's all governed by contract and family law and statute. It really, abuse and everything else don't really matter. And in fact, unfortunately, I think most folks on the call probably know this trend. Some judges in the US do look negatively. The family law system, I think, is toxic. There's a lot that hurt specifically women, but any victims of abuse really. But so some judges will look at abuse allegations very, very suspiciously. And so what you need to know about that also, litigants in family law are not provided with an attorney, again, unless it's a child removal. That's when that legal aid services program come in. And again, all of this is just going to be pled out through family court. We don't have attorneys that help that, and victims' rights generally don't get implicated in the family justice system. So we stay away from that with a 10-foot pole, but questions about it always come up. Moving on
There's so
to
much, there's so much overlap too. I just want to say, and we see it all the time. Some of the best victims advocates I have seen are people who come up through the DV process and who know how to handle those cases, or who have handled divorces where there are allegations of SA or CSA.
So then we've got the criminal justice system. Micah, is there any movement to change the family law system? Yes, all the time.
Yeah, there's a lot, and there's a ton on social media. You can learn a lot if your algo presents you with the right accounts to follow. There are a lot of different kind of movements going on in terms of fairness to parents. There's concepts called parental alienation, which are deeply impacting how people are treated as they go through that process. So there's a lot going on. And people trying to kind of balance things out and make it a little bit more fair. It's a very expensive process to go through. And there isn't any safety net in terms of finances to help people, especially when there are allegations of DV or SA or CSA.
And it's interesting because a lot of those movements are grassroots. As far as there, I'm trying to think. There are obviously many DV organizations and nonprofits, but as far as them trying to change the fairness of family laws, I don't think they get into that as much. There really aren't too many organizations that focus on that. Do you believe victims are re-victimized when they have to pay expenses as a result of the crime? Yes, and we're going to talk about that in about 2 seconds. Yes, victims are absolutely re-victimized when they have to pay. And again, we're going to talk about why being a victim of a crime can be very expensive. Micah, would you like to explain the criminal justice system? I think most people on this call probably know this, but I like to at least set the table and have us set the table so we know when we're drawing the comparisons what the basics are.
Yeah, there's a lot of misunderstanding too about who has what title and who has what rights when we're talking about the criminal justice system. So I think it is important to go over the basics again. So there's a defendant. That's the person who has been alleged to have committed a crime, whatever the crime is. There's the prosecution. That's the district attorney's or the AG's office, whatever the prosecuting body is that has the authority in the case to make the major decisions. That's like what types of charges to bring, what crimes have purportedly been committed, whether to agree to a plea bargain, and if so, what kind of sentence to recommend. Then there's the victim, and in civil law, we would call them a plaintiff. And in the criminal justice system, they're a witness to the criminal case, and they have the right to participate and to be present in some context and at some proceedings, but it's a limited extent, and it's not a role where you're calling all of the shots like you might in a civil case. And then, of course, we have the judge and the jury, and those are the ultimate deciders of guilt or innocence, and then what the appropriate punishment would be.
And then oh, go ahead. Yep.
I was just going to go on and say a little bit more. You know, I think it's important for people to understand when they're a victim of a crime, the defendant has committed the crime and is charged with a crime against the people of the state of California or the people of the city and county of San Francisco. And that's hard for survivors of crime to understand, because they're the ones who were victimized. And it's important for all of us to recognize, and when we're talking to victims of crime, to help them understand that the DA doesn't represent them individually. They're representing the people. And so it doesn't feel like a personal representative, because as hard as they try, it's not necessarily going to be a personal representative, and they're going to be making decisions that are appropriate for the people, if that makes sense. The other thing I want to say is the perpetrators are presumed innocent. We all know those constitutional standards from our law school educations, from watching you know, all the true crime documentaries that we all watch.
Yep. And I think those are the two most important points: is the state must prove beyond a reasonable doubt. And that's a heavy, heavy burden. And I think, frankly, it'll be interesting to see, bringing it current, what comes out in the Diddy trial, because those attorneys, and I think this is a great example, the attorneys rested, his defense attorneys rested without calling anything. And they're basically saying the state didn't prove it in their case. And it is a heavy burden. And our law school professors were always so cheesy, but they, you know, you have the scales of justice, and for this, and we'll talk about what it is for a civil case, which is very different in a second, but you literally have to have a rock on that one side. It can't be that it probably happened. It has to be there's very little doubt. Because again, you do start with the idea that the perpetrator is presumed innocent.
And so, you know, when you're in a criminal case, you always talk about it's just a feather on that side of the scale. In the civil context, we only have to get 51%. It's a much, much lower standard.
Mm-hmm. So there are definitely advantages and disadvantages. And Micah is one of the attorneys that does work with her victims. Not all attorneys do this, but she does work with her clients throughout the criminal process. So we want to talk somewhat, and I think, Micah, you covered some of these already, but just the advantages and the disadvantages that your clients feel and how it might re-victimize them sometimes.
Yeah, so the first thing that we do when we're taking on a new client is ask them what justice looks like to them, ask them what they want to obtain through the process, because the civil justice system to a large extent, and the criminal justice system to a much larger extent, are very limited. So, you know, if someone comes into us and says, we want, you know, the person to be locked up, but we know their criminal statute of limitations, for example, has been blown, we're going to have an honest conversation and say, we can't obtain that for you, but we can try and do this. I have clients, because I do a lot of the legislative work, who come in and say, I want to see the law changed. And I can explain that process to them, but it's not something that, you know, I can guarantee. So we just want to explain all of the different options, what the advantages are, what the disadvantages are, and help them achieve what feels like a sense of justice in a process that feels unjust almost every step of the way. So, you know, some of the advantages to going through the criminal process is the person being put away. That feels like justice to a lot of people. They want that perpetrator punished and for them to be behind bars so they can't do to anyone else what they had done to them. And that is a huge motivating factor for a lot of people coming forward with respect to SA cases and CSA cases. That is the number one thing I hear. I want to tell my story because I want to protect other people. I don't want this to happen to anyone else. The disadvantages are the lack of control, the defendant's rights being, trumping the victim's rights in terms of process. The defendants control the flow. And when the criminal trial happens, I have a case right now, the case has been set for trial 35 times and, we're still waiting. And so it's a lot longer of a delay than it would be in a civil case. After a perpetrator gets convicted, let's say the criminal case goes the way we want it to go, there's still a lot of bills that the victim, the crime, victim is left with. That doesn't mean there's, any financial justice at the end of the day. So that's a disadvantage.
And since you brought that up, let's talk about restitution and compensation, specifically in California. Do you work on this much? Do you get a chance to work on this?
I do, because a lot of the cases that I work on are what we call CSAM cases. That's child sexual abuse material cases. And those are cases where a child is forced or trafficked into making what we used to call child pornography, but that name just doesn't do justice to what the young victims actually go through. And those crimes, when we uncover the images and them being trafficked, the federal laws kind of have built in a restitution process for us. So those, every time they're transmitted, there's a value under federal law, and we go in and we seek the restitution that we can seek if there's a pot of money somewhere, which is a huge caveat to a restitution claim. But we will also, if the person has assets after they've been convicted in any, regular SA or CSA case.
And I think that's one of the things we always emphasize, especially with restitution outside of the civil justice system. Restitution is coming directly from the defendants, and a lot of them have spent all of their money on attorney's fees, and they're now incarcerated. And so they're working in the commissary and whatever, and making 25 cents on the dollar. And you can't draw blood from a stone. And so restitution is very difficult. And California, there aren't quite as many hoops to jump through as some states, but there still is some documentation that is required. And then every state has a victims compensation program. In California, it's about middle of the road, would be my opinion from different states we look at. It does require cooperation with both law enforcement and prosecution, which sometimes is very difficult for victims. And they have to cooperate all the way through the pendency of the trial, which is unfortunate. It has to be filed with and reported. There are different reporting requirements. You have to report it within 7 years of the injury or 7 years after the victim turns 21. And then there are, of course, caps. And a lot of those caps do not cover the medical expenses, the lost work. Again, it's just really expensive to be a victim of crime sometimes. And so that's where we get into the civil justice system, which really does give victims an alternative. There's a lot of bad press on it. Micah and I are both going to talk about why that's not deserved bad press, but it really gives victims an opportunity, whether or not the prosecution was successful, to find vindication in other ways, and sometimes against other parties. Before we get into that, I've read 3 questions, and they're not going to come up later, so I think we should talk about them now before we really get into the meat and potatoes. Are legislators fighting to change the laws and victims' rights in order to assist victims when it comes to the different types of issues we've already discussed? And what would you like to see changed most about this difficult process?
Yes.
Yes, and yes.
Yes and yes. They are. We have some great legislators here in California. I do a ton of lobbying, and I always try to have my finger on the pulse of what is out there that could impact victims of crime. I'm really focused on things like child abuse, domestic violence, SA, CSA cases. Um, and there's almost, every year, 3 to 5 different pieces of legislation that have a good chance of passing and a good chance of moving the needle in terms of more rights, more protection for people who have experienced sexual violence or other, sex-based crimes. So, it's not easy to get these bills through. A lot of times what happens is there are competing bills in the Assembly and the Senate. They get watered down to get passed. We also, because of financial shortcomings here in California, everything has to go through the Appropriations Committee of each house. And I like to say the Appropriations Committee is where all good bills go to die. So the Appropriation Committee decides if there's a fiscal impact on the state of California, which it almost always makes that decision in the yes column, and then it kills the bill because we are so in debt that we don't want any more pieces of legislation to come in that are going to impact our budget. But that doesn't mean we give up on them. We get them reintroduced, year after year, and eventually we will be able to get a lot of them passed. We are also seeing this type of legislation from both parties. For a long while, the pro civil justice legislation was only coming from the Democratic side, but we are seeing it from both sides now. This is an issue that doesn't have political, doesn't have a political persuasion. So, and the statute in California for the statute of limitations for sexual abuse has been amended so many times. It's one of the ugliest statutes because it's been amended so many times. It's like, if this, then that. You need a flow chart to know which provision you're really looking at. But the answer is yes. People care about these issues that are in those seats. We're starting to see people who worked in this space running for office and continuing to work on these issues.
In respect to family law, what are some of the best practices? I don't know if either one of us can answer this, but we'll try. What are some of the best practices for addressing rapists' parental rights when advocating for the survivor or representing the survivor? Similarly, is there any discussion related to supporting survivors of human trafficking navigating family court and child custody?
Oof.
Oof. I'll jump in and say we've got some phenomenal partners who are in the trafficking space. We're not as deeply into it because it is such a special, you can only do trafficking from a nonprofit's perspective if you choose to do trafficking. I would recommend looking at the National Center Against Sexual Exploitation. It's NCOSE, NCOSE. And the National Center, NCLVI, National Crime Victim, NCVLI, National Crime Victims Legal Institute. They will both have lots of information on that.
Yeah, but you're not gonna find law firms that are gonna be able to have dual specialty. So our law firm deals with human trafficking, but not in the context of child custody issues or a divorce, a dissolution of marriage. So you're really going to have to look for a nonprofit. But that's a really great question. I have never been asked that question. I've never had to look for an organization that does that. So I'm going to put that on my to-do list and see if we can find someone, a resource.
Well, I've got a similar one coming up. Are you ready for it?
Oh, okay.
And I'm struggling with it too, but I'm going to try and you try. But similarly, if a victim experiences trafficking and or other forms of sexual violence in another state, this is a conflicts of law. I hope you took it. I hope you took that class and you're ready. Conflicts of law.
30 years ago? Okay.
Um, if they experience that in another state other than California, or if they're crossing state lines, are we able to link with an attorney or legal service provider with NCVC? Yes, we can link you with a legal service provider, but could that case be tried in another state, or would it be California? Basically, how, when it's trafficking, and especially across state lines, or if it's a California resident, but there was no crossing state lines, how do we pick our jurisdiction?
So the good news is there is a federal human trafficking statute and a California state human trafficking statute. So you can file civilly in state court or civilly in federal court, wherever the trafficking took place federally, you can file. So that's an easy one. We got you. We can help you do that analysis and figure out where you have one, the most appropriate jurisdiction, but two, the best judges who are used to seeing those types of claims and cases. Not all federal judges are created equal. Not all jury pools, most importantly, are created equal. So if you're looking at that kind of jurisdictional question and what will give you the biggest boost in terms of getting a judge to keep your case and not dismiss it for some nonsense, and then getting you to trial with a jury pool who understands, that human trafficking exists and is real, because we face that kind of disbelief all the time in our trafficking cases. People think it's like some Liam Neeson movie that only happens in, Eastern Europe, where someone is grabbed off the street with a, pillowcase pulled over their head and then they're trafficked. And that does happen, but that's a very small percentage of how people are trafficked these days. It's almost predominantly online.
And it's a similar answer. There is not a federal statute, but for general sexual assault and rape, there are similar considerations. Oftentimes, even if the assault took place in another state, if you have a resident of, there's an analysis that goes into whether or not what state you can file in, and again, what state is the most favorable. And then last two questions.
I just
Let me
want to say, sorry.
please.
California also has its own civil rights statutes, which provide for enhanced remedies in some cases for rape and other sexual assault. So if it happened in California, if you can take advantage of those statutes, you can get treble damages and attorney's fees. So those are additional hammers that we have access to here in California that a lot of other states don't have. So just a little plug for, again, the good work that the California legislature has done to help protect survivors.
We've got two more questions. One leads us into our next topic, but it's the first one's an easy answer. What determines a criminal prosecution and civil cases when there's domestic and interpartner violence has happened? What would trigger the criminal prosecution would be the victim's decision to press charges and go forward with those charges. That is solely their choice. That is what triggers the criminal prosecution. Again, with civil cases, with domestic and intimate partner violences, in the way we're talking about civil cases, there are very rarely going to be successful lawsuits, because usually those I shouldn't even say that anymore. If the individuals are still married, it is going to be a difficult lawsuit because it will be viewed at with a degree of skepticism. If it is a live-in partner situation, we'll get into this in a second on why it'll be a little more difficult to file a civil case because it is against an individual. And then the other question was, if restitution comes from the defendant and they have no money to pay due to paying for their legal defense, how does a civil case work? and what happens with a criminal case. And that is leading us into civil justice, and why it's slightly different. And even if you have an individual defendant who cannot afford it, and this also answers the family law question, even if an individual defendant you cannot receive money from them, there are other alternatives. So let's start very quickly with just the same basic overview so we can draw the comparisons between civil justice and criminal justice. Micah, do you want to give us the overview?
Sure. So in the civil justice system, we have the plaintiff, that's the injured person who is then bringing a civil claim against a defendant. Um, and they have control over the case. And when I say they have control over the case, and I have to remind my clients this sometimes, it's limited control. They have control about whether to file the case. They can provide input on what types of claims. They make the ultimate decision about whether or not to accept a settlement, to go to trial, those types of things. And they have to prove, again, by that lower standard, 51%, that it's more likely than not that that particular defendant caused the harm. The defendants is a person who is going to be, if all goes well, held accountable to the victim. There can be many defendants. Sometimes there's many individual defendants. Sometimes there's an individual defendant and an entity, an institution. And with respect to these defendants, there's no presumption of innocence. They don't get that constitutional benefit.
Mm-hmm. And again, with the scales of justice, the comparison, it's more likely than not. So it's a feather, not that rock. And that is a huge advantage that I don't think can be understated.
Yeah.
Most of the cases that come into the civil justice system go under torts law. Mike and I both spent a year, probably, well, no, ours was 6 months. Was yours a year? We had torts and advanced torts.
We had torts for a year. Yeah.
So we're going to boil down a 1-year law school class into about 10 minutes. So this, almost every case will come up under torts law. Micah, do you want to explain intentional torts?
Sure. So an intentional tort, well, first of all, a tort is just a bad act, an act that harms someone. And you have to have a duty, so to not do harm, right? That's your duty, to not walk around harming people. If you do harm someone, you actually have to show that the person intended the harm, or they knew or should have known that harm would ensue. And that if they were harmed, that the harm actually caused damages that are recoverable. So those are things like, a physical injury, a psychological injury, things that you go to the doctor and can see in an x-ray, or, you have to pay for a prescription or whatever. So these are all things that you did on purpose, or you should have known they were going to result from your behavior. Driving 120 miles an hour on, a residential street, for example, is a good example of an intentional tort. So there are defenses. You can say, wasn't me, I wasn't in that car, that's not my car, I've never even seen that car. You can say, a police officer told me I can do it. There was consent for me to drive 120 miles an hour. Self-defense, I had to get away, I was being chased, that's why I was driving 120 miles an hour. Or I had to get to, my, must be people, not pets. Okay, Renee.
But try to come after my pet. Just try.
Right. I had to drive to get my grandmother from, a burning building. That's why I was driving 120 miles an hour down the street. So these are, very simple, silly examples of what an intentional tort is.
And I think the only important thing to point out here too is that for every, and I can't remember, we do have a slide for it. For every type of crime you can think of, there is a corresponding tort, whether it's battery, assault, fraud. There is something that is corresponding within the civil justice system that correlates to the criminal justice system. But the important, I have way too much on here. Oh, these slides aren't even right. What was I doing? Negligent torts. There we go. The important differentiator between the criminal justice system and the civil justice system is negligence and the idea of negligence. Negligence almost never comes into the criminal justice system. It's very hard and it has to be extremely dangerous to be able to prosecute a case for negligence. That's completely off the table in the civil justice system. So negligent torts are a huge part of our practice, and they're a huge part of how we seek justice for victims. Micah, do you want to walk through them and explain them? And these are a little more tricky because they're not quite as obvious.
Yeah, so just to give you an example of when there would be negligence in the criminal context, negligent homicide, manslaughter, something like that, where the end result of some behavior was a crime. But we live in the world of negligence, almost exclusively in our civil justice cases related to SA/CSA cases. And it seems kind of counterintuitive. I mean, it wasn't an accident that the, priest sexually assaulted an altar boy, right? It's not an accident, but it's still in the world of negligence because we're saying they should have known because there's a duty. They breached the duty. There was a harm and then damages occurred. It's very similar to the intentional torts. We're just kind of saying it's not the same. They didn't take intentional steps to do it. And there's defenses to negligence claims, comparative negligence. Like, so yes, I did those things, but you also did something that contributed. These all fail immediately when we're talking about CSA cases because there is no ability to consent or to be negligent or to contribute to, for a child to contribute to its own sexual, his or her own sexual abuse. But some of the defenses that might be impacted or might actually impact the claims are statutes of limitations, depending on the state that you're in. In California, again, we have a good legislature. It is now after 2024, we have no further statutes of limitations on child sexual abuse cases. They are gone. A child can process the abuse that occurred and file whenever they would like to file forever. Contributory negligence, again, in an SA/CSA case, that's really not going to come into play. And waiver, if it's a CSA case, is not going to come into play and probably wouldn't. You can't really waive this type of misconduct.
I think one of the interesting ones that I always like to talk about, and it comes up later in how to prep a victim, is damages unrelated. So a lot of folks will try to say they might be having these mental health concerns, they might be treating with this, but this rape, this sexual assault happened at the age of 21, and they were doing this, this, and this from the ages of 14 to 15. Damages were completely unrelated to this. And that's one of the most important things to talk about, which we're going to get to in about 15 minutes, of how to pick an attorney to prep that, because that will come up more than you expect. The interesting thing about negligence, and the reason negligence is so helpful in these cases, is that you have a whole host of other potential defendants that you can pull from to seek justice. And the interesting thing, and this is where we'll get into some of the bad press too, there's a lot of bad press against individuals that are seeking justice for, especially for sexual assault claims. I think one of the biggest criticisms I've heard of Cassie in the Diddy case and all of these other women is they just want money. A lot of times that's actually never true. It's a complete falsehood. And I think the important thing to remember is a lot of times we know that cases don't go to prosecution. So this is the only choice. that a lot of victims have. And we've done a lot of interviews with individuals who have been sexually assaulted by coaches within within Michigan State and Ohio State, within the Olympics, within the Catholic Church. And almost every single victim said every time, the rape, the sexual assault was one thing. It was the institutions afterwards that screwed me up even more, because I was supposed to trust these people. And not only did they not protect me, they went out of their way to throw me under the bus.
Yeah.
So
It's
negligence allows us to get different folks into these lawsuits, but to set the table, let's start with just first party defendants. Micah, do you want to explain them?
Sure. Yeah. And I just want to go back for a second because I want to echo a little bit what you said. We hear that refrain all the time. It's just about the money. It's just about the money. And that's all the civil justice system is. That's a systemic criticism. And if that's the criticism, that's fine. But that's all they can get. And so that's really the messaging we have to be parroting out there when people make that claim, because we don't have control over the criminal justice system. We can ask the police to investigate. We can ask the police to turn over to the DA and ask the DA to press charges, and the DAs can decline. And then what? The survivors, the only access to justice they have then is a civil case. And the only thing the civil justice process can do is provide money. And every single time I hand a client a check, it's not like it washes away any of the pain or any of the trauma that they've experienced. It is not an equalizer. And I have had clients time and time again say, this feels like rape money and I don't even want it. So I hate that criticism because it's just ignorant.
Mhm. Mhm.
I will step off my soapbox and talk about how first party defendants, aren't always the best options. So and why also institutional abuse is so damaging and so traumatic for people, because they turn to the institution, the organization that they thought was going to protect them, that they relied on, that they trusted in. And unfortunately, they're just not there for them. And they enable what happened to continue to happen to them and to others. So we've got the offender, the actual perpetrator. We've got the co-conspirators or the enablers, the people around the offender who knew what was going on, or should have known for a variety of reasons. There was enough evidence there, but they turned the other way. Either they were getting promoted. There was something in it for them, and that's why they were enabling the abuse to happen. Same thing as, accomplices, and then parents who didn't have any sort of training, who didn't know what they should be looking for. Again, who were getting, more attention for their child. If the coach was, providing extra training for the kid, or the teacher was providing additional, after school tutoring or whatever it was, there was some special attention that they wanted their kid to continue to get. It was one of the hardest things we saw in the Catholic school cases forever, for parents who thought the priest coming over for Friday night dinner, was an honor. They didn't realize their son was being groomed, and what was happening when the priest went to pray alone with the child in the bedroom after dinner or whatever was going on. But these aren't always the best options, Renee says.
And they're not. And I think that's very hard, especially for some of the individuals who come to us to understand, because they want justice against this person. And there is certainly an ideal and an image that you see of having that person at at the table, at the defendant's table, in handcuffs, in a jumpsuit, to really drive home that image for the jury. But and is California joint and several? How does California work damages?
Yeah, joint and several.
Okay, so
It depends on the claim.
So if I had a priest sitting at the table and I was suing the priest in the Catholic Church, and the jury found that the priest was 89% responsible for the abuse, would the Catholic Church only have to pay 11%
They would both be on the verdict form.
for
So
100%?
the jury would allocate.
Okay. Okay. Would they allocate fault or would they allocate amounts?
Both.
Okay. Okay.
Depends on how the form is written.
And so sometimes you want to be very careful, but that's part of the reason these aren't always the best options. And as somebody just asked, if you have a defendant who is a first party defendant who has no money, what good does it do? So that is where negligence brings in all of these types of cases. And Micah, do you want to give some of the highlights of some of these? Because I think some of them jump out to people, like random employers at maybe a restaurant, hotels. How do we pull some of these people in?
Yeah, so hotels, for example, are, a prime target for human trafficking cases. And what we see in those cases, sadly, time and time again, is actual knowledge of the folks who worked at the hotels, not just housekeeping, her going in to clean up rooms, but front desk folks, bellhops. And we also see that a lot of times the managers are getting kickbacks. The bellmen are getting freebies to keep their mouths shut and not report them. So there's a lot going on at hotels and motels. Same with entertainment venues, especially if we're talking about, quote unquote, gentlemen's clubs. There's a lot there. Any sort of employer, if there's assault, abuse, trafficking going on their premises, if they have knowledge. We see it at restaurants, of course, nursing homes where, a lot of times patients are there, elderly with dementia, incapacitated, and you see the staff sexually abusing and assaulting the patients who can't speak or who are too demented to be able to communicate in an coherent way what's actually happening with them. Childcare facilities of any form, and I'll include education in that. So nursery schools, regular primary schools, any youth serving organization. We always say in my office, the perpetrators go to where the kids are. So if there are children there, if there are people there who can't fight off a perpetrator, who don't have the capacity to report, you are going to see abuse there, unfortunately. Bars, we see a lot of times it's the bartenders who are spiking drinks, unfortunately. And so one of the things that we do in my office is try and help, local bars do education to bartenders about angel shots and other types of campaigns, so the bartenders can learn how to identify who's being dosed and how to keep their patrons safe. Of course, we know about, horrible abuses in prisons and jails. And then really anything run by the government, from health clinics, to the military.
And we should call out that caveat with the government, it's very difficult. So if it is tribal or native dealing, it goes into contract law, interestingly, because it's considered a violation of the treaty. And then you are actually fighting with the DOJ. So the government cases are very difficult. It is the same with any military assault cases. You have the Ferris Doctrine, which is possibly being overturned, but the Ferris Doctrine means that you can't sue for medical malpractice. You cannot sue the Army for medical malpractice while active duty. That has magically been applied to sexual assault cases. And so the government's a very, very, very tricky one, and you want to make sure you have a very, very, very specialized attorney.
Yeah, and
Yeah.
one of the things I want to just put out there is we see a lot of sexual abuse and assault with medical doctors, on patients of all ages, particularly children, particularly at the federal government run, local clinics. So clinics that are meant to serve low income people, monolingual folks. And a lot of times lawyers don't know that those are federally funded clinics, and you have to give notice to HHS. And you have to give HHS the opportunity to intervene in that case. So you need to file in federal court, not state court, and give them the opportunity, and that will slow a case down by at least a year. So you got to make sure you've got lawyers, if you're thinking about a civil case, who understand the interplay between, who the defendants are and all the special rules that might apply to them.
We just got a question. Are we saying a rape victim can't sue the government if the rape happens while on active duty? I'm going to go lawyer and say it depends. Do you want to give the why it depends?
Because of all the facts. So
Hmm.
what's the question again? Exactly.
Are you saying a rape victim can't sue the government if the rape happens while on active duty?
No, I think that you can. I think it's very difficult,
Yes.
is what we're saying. But
So it is. Yeah,
I would never say, I mean, I'm all for pushing boundaries and seeing what other claims that you could potentially bring in. And it's up to the government. So you file what's called a government tort claim, and the government can accept the claim or reject the claim. And every once in a while, if there's another defendant, they're going to probably punt to the other defendant. But, find a lawyer who's experienced in the area, and see what you can do.
Because so if you are an active duty military member and you are raped, it depends on who does that. And whether or not the government had reason to know. If you are a civilian and raped by an active duty officer, that is a more challenging question even than the first question, because it depends on a lot of things, like were you on a military base? It's the same principle of if you're raped by an active duty officer and you're not on base because you're in a bar, you wouldn't hold the employer responsible usually. If a priest assaulted somebody in a bar, we wouldn't necessarily have a case against the Catholic Church. So it's another one of those. There are a lot of layers that you have to walk through. It's just the government makes it significantly more difficult because you're also not facing a usual defendant who are paying their own legal bills. You're facing the power of the U.S. government. Statutes of limitations and damages. We're going to go slow through these because they're always the most confusing part, but these are the really special considerations that we need you to know about, and it's really why we're here. We're going to talk about the reasons that it's important for attorneys to know these statutes of limitations, to know special challenges, and there are always possibly ways around them and things like that. But I think one of the most newsworthy items and one of the things that everybody gets confused by is the statutes of limitations. So let's start with that. Micah, would you like to explain what these statute of limitations are and walk us through them in California?
Like I said, it's a mess. Every time I file a case, I go through our statute because it changes so much and it is so all over the place. And it's a beautiful thing and also a hot mess, like most people I know. So let's start with window legislation. So what we have done in California a few times now since I've been practicing, the first time was in the early 2000s, where we had our first clergy only window. It's a look back window, which says we are opening up the statute of limitations to allow folks whose statute has passed, has long run, to now come into court and file these long, these stale claims. Everyone can come in from this date to that date and file their claims. If you don't get it in this window, they're dead again, essentially, forever and ever. That turned out to not be true forever and ever, but that's how it was written in the early 2000s. That's called window legislation, or a look back window, because we're looking into the past and we're pulling forward all the claims that people are ready emotionally, and whatever else they need to do to get ready, and have gotten ready to file. So we have generally adults within 10 years of an event. So the derogatory event, the sexual assault, the whatever it is, or 3 years of the discovery of any physical or psychological injury caused by the abuse. Now, people have a lot of trouble with the second half. Within 10 years is very clear, right? Within 3 years of the discovery is a case, like I have a case right now. It's a brother-sister incest case where my client's brother raped her from when she was 8 years old to 14 years old, and she had suppressed all of the memories until she retired. She had this, big, fancy, important, high stress, high achieving job. And when she retired, she finally just kind of decompressed and relaxed for the first time in 40 years. And all of these memories came flooding back. And she realized how impacted she had been by these memories. And so we relied on this statute and filed within 3 years of the discovery of the harm that had occurred, the psychological harm that occurred. We also have the ability for victims who are under the age of 18, for abuse that occurred on or before January 1st of 2024 until they turn 40. And as I said earlier, lastly, and I think this is, most important, and I hope all states follow this kind of a trend, which is any incident after January 1 of 2024 do not have a statute of limitations. There are other statutes that you need to be mindful of, because a lot of times our cases are not just pure sexual assault. There are other things that go with it. Fraud, professional malpractice. We see a lot, sadly, a lot of doctor abuse cases. And medical negligence, you have 1 to 3 years, depending on what type of malpractice you have and when it was discovered. And then general personal injury, you've got 2 years in the state of California.
And I want to add 2 things. We're going to talk, but I want everybody to put a pin in that 3 years within discovery. We're going to talk about how that affects you all, first of all, as advocates in a hot second. But second of all, just to point out that that is where, when you are helping individuals work through and find an attorney, make sure they've done this work a lot. We have seen so many, because California is one of the few states that still has discovery in it, and there's a question of when discovery is. We've seen a lot of attorneys blow these cases because they say incorrect things about when a victim may or may not have remembered. We've had one attorney who hosted a press conference, and the victim implied that she remembered before she had told him she remembered, and the case got dismissed. I mean, and it was because the attorney wanted attention. That's not one of our members, by the way. But so they're just, it seems like such a small little part, but there are so many different ways that within discovery could really make or break a case. And then the other thing is on professional malpractice. We had a super interesting case at the NCVBA that was not actually the physician assaulting the child. But this goes to show you how you can hold other people responsible for the harm that's done. We had a young girl who was primarily Spanish speaking, as was her mother, and she was being raped by her stepfather. She was 13. She started missing her periods. The mom took her to the doctor. There was a very clear language barrier. The mom kept trying to say she's missing her periods, and the doctor ran a pregnancy test. It was positive. They didn't even read the pregnancy test. It went into her file. This child was pregnant. He sent her back home and just said she's 13. Her periods are going to be irregular. The mom came back a second time and then a third time. The father continued to rape the child for those 6 months. And then the child, by the time they discovered that she was pregnant, because the pregnancy test was actually red, the child, it was too late for an abortion. So the child was forced to give birth. So there was a very successful malpractice case in that. So it can go even a little bit further than just a physician abusing. And then we do have a question. Can you name a case in which a sexual assault victim successfully sued the federal government for negligence in sexual assault? Yes, and you can watch a whole documentary on it, and that is one of our attorneys. Mike, I don't know if you've ever done one. The one that's coming to mind for me, one of our attorneys, his name is Peter Jancy. He sued the U.S. government for violation of treaty. Dr. Stanley Patrick Weber. And if you look up PBS Predator on the Reservation, Dr. Stanley Patrick Weber was raping children in Indian Health Services for years. I mean, and they just kept passing him, and they knew. And they passed him from reservation to reservation to reservation. And eventually he was arrested. There were actually stories about how much evidence he was allowed to destroy before the federal officials came to get him. But Peter did successfully sue the US government, unfortunately for a lot of his victims because of the cultural implications. They were incarcerated. They had suffered years of alcoholism. There was just a lot of really tragic work around those cases. And then Micah, do you have any?
No.
No, we've got a couple of attorneys that do military assault. But there's like a handful, and it doesn't matter the state. I send the military cases to them because they're so very tricky. And even those attorneys aren't taking most of our cases, just because it's such a huge uphill battle. And we're going to talk about in a second, the process of going through one of these cases can be extremely re-traumatizing. But again, we're going to talk about that in a second, because like I said, we always talk too much and we've got to fly through the important parts. So damages in civil cases.
And I just really quickly, I want to remind folks that medical doctors are mandated reporters. So if a doctor is, reading understands that there's abuse, or is reading a pregnancy test of a child, that's per se abuse. That child cannot consent. That's another entity or another person to bring into a case. The people reviewing those medical records should have also either faced discipline or been named in the lawsuit. Okay, just had to throw that out.
So damages are also important in crime victims cases. And this is, again, where you want an attorney. They're pretty simple: compensatory, economic versus non-economic. Economic are the damages you actually put money out for: medical bills, lost work, et cetera, et cetera. But then there's non-economic. And this is where, and Mike is honestly one of the best at it. It's the damages that can't be quantified. Car accident cases are easy. You show a scar. These types of cases, these sexual assault types of cases, it's really hard. So Micah, do you want to talk about how you walk juries through some of that?
Yeah, I'll give you the short version, just because we're probably short on time. But when I talk to a jury about economic and non-economic damages, I refer to the economic damages as damages to your pocketbook. That's where you're going to get a bill, you're going to pay the bill. It's clear, easy, we all understand that. The important damages, the damages that don't go away, that you can't pay to get rid of, are the damages to the person. And I always touch my chest or my heart, because I want everyone to remember that there is a human being here who has been altered, who has been changed, who has been damaged in a way that will not ever recover. We can send them to the best therapist, get them the best medication, and that will help certainly, and they need that help, but they're never going to go back to a baseline where there isn't trauma because their neurochemistry has been changed. So damage to the pocketbook and damage to the person. That's how I help the jury understand those differences.
And everybody does need to know there are attempts to limit and put caps on damages in California on child sex abuse cases. Specifically, it's happening right now. So everybody that's asking us what legislation we'd like to see, I'm not technically allowed to say because I'm not allowed to report for any legislation, but Mike is allowed to say.
Yeah, we want to kill that bill.
So
That's
there
what we want to do.
is there another bill currently? We went through so everybody knows we went through two bills where there were very active attempts to grossly limit damages for victims of child sex abuse. Is there one that's active right now?
Here's how California works. So in the beginning, just real quickly, in the beginning of the year in January, everyone puts in what's called a spot bill. They usually don't have their poop in a group well enough to have full language for a bill. Every once in a while they do. So they put in some language and it's just a placeholder. Then the bills get language put in, they work their way through, we get a chance to kill it or support it. We have killed some legislation, but what can happen over the summer, just about now, is what's called a gut and amend. So people who are trying to do the bad stuff will find a vessel, what was a spot bill, and gut it and amend it and turn it into a whole nother bill that could be another attempt to kill. And these, the primary supporters are Uber and the Waffle House, and governmental entities, because they are facing, millions and millions of dollars of righteous claims because they supported and allowed children to be sexually abused for years in a variety of respects.
And I see the question and this is a quick answer, for non-economic damages, can the victim be reimbursed for therapy and mental health treatment? Yes, those are actually economic damages. And they can be reimbursed dollar for dollar because they are damages you can absolutely show, prove, and bring the receipts for. And then punitive damages are unique in civil cases, and they're damages that are actually meant to punish. So it's when you can get a jury very angry. It's when things have been ignored for a long time. They are meant, and this is one of the beautiful parts. This is one of the true justice parts of the civil justice system. They're the parts that say, you really messed up here and you need to fix yourself and don't do it again. And because you did it and you knew it, we're going to try to get more money from you. You're going to have to pay out for this bad behavior.
Two things on punitive damages. One is the United States Supreme Court has essentially said you can get 8 to 9 times your underlying judgment. So a multiplier of 8. Also, if you have a medical provider, you have to do a special motion to be able to claim punitive damages. And if you don't do it in time, and people mess this up because they don't know what they're doing, if you don't do it in time, you don't get the punitive damages. And there's also a way to talk about punishing people without using that language to get juries riled up, so you can get them thinking in a punitive way, just by planting some language in there, getting them mad.
And California is interesting, and I call this out for our friends because I did see some folks check out from not California. California does not require a payment of punitive damages. There are some states that will take up to 75% of the punitive damages, unfortunately. But California is not one, correct? That
We
all
have
goes.
we have a statute that says we are supposed to. I don't think anyone has ever.
Okay, they've never come after it. Okay, so this is my favorite part because I get to get on my soapbox. Mike will get on her soapbox. We've talked to you all about the technicalities of the legal justice system, but this is the part that we really get to delve into the advantages of the civil justice system. There are so many besides money, and these are some of my favorites. I don't know, Micah, do you want to talk about any specifics of these? Because I have special ones I'll call out too.
You do you, and then I'll talk about whatever's left.
I think overall, and this encompasses a lot of these, this is where we actually see action and change for society. And that's in the accountability. You know, the Catholic Church was not doing anything even after the spotlight issues came out from the Boston Globe, which they're total rock stars for doing that. The Catholic Church still didn't have impetus to change anything, and they didn't until they started losing money. All of these folks, when you frankly go after their pocketbooks, that's when they change. And I alluded to it earlier, but Diddy's another great example. Diddy is even more dangerous from prison. He is. So going to the police, going somewhere, that's great. If we could get him incarcerated, fine. But he is just as, if not more dangerous from prison. The way you get people like Diddy to realize what they've done is really by these civil suits. And the one thing I will point out is that civil suits actually allow for more solutions than just money. We've had so many victims that have come to us that have said, I'm willing to settle a case for a slightly lower amount. We had one attorney in Ohio, and I adore him. And his client came to him and said, I'm good to settle it for this pretty low amount. And he said, I think I can get you twice that. And she said, I don't want twice that. What I want is for the school to let me come in and teach kids about what this looks like. We've seen so many victims have the ability to go ahead and require that policies are changed, and that schools, the churches, the daycares have policies in writing that they have to prove compliance to. It's really the way we start to see the movement and the change in the system.
Yes, yes, yes. And these kinds of things, the non-monetary gets that we can negotiate are what it's all about. I feel so lucky to be able to do the job that I do because I get to watch my clients go from a sense of victimhood and disempowerment to a sense of empowerment by the time this process is over, because they get to decide, what accountability looks like for them within the confines. And sometimes it's, just asking to go in and teach a class. It's asking for the non-monetary terms. We want you to have to, make everyone go through this type of training, or, this is what accountability looks like for me. And a lot of times it looks like advocacy. So we see people who have been through this who say, this system failed me. I'm going to get involved and see if I can help change the system for the next person who comes, along. And there's so much that can be done. It's just a beautiful process to watch. There's really no ability to do that in the criminal justice process. And, because for so long, our statutes of limitations have been so rigid and so difficult, so many people would come to me with their statutes blown. And the only thing they could do turned out to be the best thing they could do for themselves, which is to get involved, to advocate, to get involved in public policy, to do volunteer work at a rape crisis center or whatever it is, figure out a way to, to give back.
Mm-hmm. And I think that's a good point too. For some folks, the statute might be blown, something might have happened. People get very frustrated with me because I maybe refer 1% of the cases that come to us. Those are for very distinct reasons, because as wonderful as civil litigation is, there are absolute disadvantages to it. And you really want to make sure you have an attorney who's walking the client through what the full process can be. And the first one we have is the simplest. Civil actions are expensive. And at the end of the day, the victims are responsible for those expenses. Most attorneys, here's an FYI, most attorneys are covering those costs. And those expenses don't come out until the very end when everything is settled. And if the case doesn't settle, or if there's not a win, the victims or the attorney eats that themselves. But legally, victims are responsible for that. They're very, very expensive cases. But the more important part is re-victimization. And I want Micah to kind of talk through her process for helping victims get through a trial and why these trials might actually be more traumatic than finding a different form of justice.
Yeah, they can be very, very traumatic. And what I do at the very beginning of my relationship with my clients is give them a little bit of, a law school, a mini law school tutorial so they understand what's coming down the pipeline for them. I go over what discovery is, I go over what a deposition looks like. We're going to do it again when we're actually in that process, but I want them to know there's a lot of different parts to it. It's not we file a lawsuit and maybe there's a press conference or, if their perpetrator is famous, someone finds out and it gets, it's a lot of tedious little steps and they have to participate. And so we talk about what's expected of them and whether they're ready for that and how they need to show up and how they need to be ready to show up throughout that process. I got so tired of giving that speech, I wrote a book. So now my book. Here's my book. Please read chapter 13 through chapter 17. And civil litigation is very expensive. And it's not for the faint. It's not for the faint of heart. It can take 3 to 5 years. Courts are still backed up because of COVID. In California, you have 5 years to bring your case to trial from the time you file it. We are bumping up against that 5-year limitation on almost all of our cases and having to stipulate to extend that timeline because the courts are just jam-packed. So it feels a lot like hurry up and wait, and you have to be ready for that. And you have to be in a place where that doesn't feel like more abuse or the perpetrator getting over on you because he or she gets more time and you're waiting for, things to resolve and so you can move on. I'll tell you something about deposition fees. It's probably $5,000 a deposition. That's a lot of money. When I started practicing back in the horse and buggy days, a deposition cost, $250 for the transcript. And if you had a video, another $500. Things are very expensive now. Expert witnesses, we try to always use the best of the best. $20,000 to $30,000 before they're even deposed, which means their deposition is probably twice that, and then at trial it's 3 times that. Very, very expensive. But we want the best, and we're gonna win. So we're gonna do what we need to do to make sure you have the best experts, and we take all the depositions we need to take. Re-victimization is a real thing. Telling your story over and over again is a challenge. I try to only do a deep dive once before your deposition and then once before you testify at trial. And it's you've got to be ready to go through this. And this is why when we turn away a case, a lot of times it's because there's no way to recover for you. And we don't want you to go through this for nothing. It's a lot to go through for nothing. Meaning we can't get anything out of the case for you. So those are the damages to civil litigation. And having to also, the last piece of it is having to tell people you haven't told yet.
Yep.
What happened.
I think the important part of that is what we learned, which is it's called putting yourself at issue. So when you are alleging that you were injured, you are the person that they are investigating within this case. And so defense attorneys do have a right to ask for, and we talked about this earlier, what were your drug records when you were a teenager? What trauma? When were you hospitalized when you were 4? They can bring everything in because if you're putting your health, your state, your body state at issue, they have every right to look for every single reason that might not be the reason that those damages were done. And a lot of them use it not just for that innocuous reason, but for the more nefarious reason of trying to intimidate. Defense attorneys have gotten much better. Don't get me wrong. But a lot of I have to say it. But a lot of them will do that. So your role as advocates, we've given you a lot of information today. There are a lot of super important things that we need you to know since we've now given you all of this information. Victim advocates have what's called qualified privilege, which means a court can compel disclosure of your records of anything you've written. Where one of the most glaring places this becomes super important is earlier when we were talking about in California, that discovery within 3 years of discovery. If there are therapy notes that indicate something was wrong that could have been discovered, anything like that that comes in can be reviewed by the defense if the court decides to compel it. And the definition even of victim advocate is so heavily dependent. There are rules upon rules upon rules upon what type of job you have, what type of organization it is. So we always say, please, 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 before you're discussing civil cases with individuals, consult with your employer, make sure that you know what your policies are regarding whether or not you turn your notes over, how protected your notes are. And always, you cannot give victims legal advice or guarantees. The best thing you can do is tell them that there's this option and help them suss out their choices as far as the option goes. But again, in California, you do have to be very, very careful. And this is my chance to brag on folks like Micah and our whole bar. And I think we've said it a couple of times today. It's so important that you're listening to everything an attorney says, how they're saying it, how they're asking the client questions, even in the first interview. Do they understand how trauma impacts your brain? Because they're going to be the ones leading that client through this. And as Micah said, these can get really scary and really, really traumatizing. So make sure that the person leading your charge isn't doing more damage than good. But we also talked about some of those very technical skills of knowing how to manipulate, not manipulate is the wrong word, knowing if a statute of limitations is truly applicable in a certain case, knowing how to protect victims' privacy and boundaries. There is a case, I'm so happy to be able to use the Diddy cases instead of Catholic Church now. It makes me very happy. But the Diddy civil lawsuits, frankly, some of them are being led by an attorney who's never actually done sexual abuse. He has just gotten into this. This is not his bread and butter. And he actually blew some of his clients' anonymity in New York, and they were no longer allowed to file under Jane Doe because he messed up the filing. And there was a very easy way around it. Our attorneys all know how to do it. Our attorneys ask each other because they get along. He is not in our bar association. He did not ask our other lawyers. But there are very easy ways that you could really do more harm if you don't know what you're doing. And unfortunately, when you start to see a lot of this in the news and the statutes news and things like that, you do get a lot of attorneys who do a lot of car accident cases that will come out of the woodwork and think that a sexual assault victim is the same thing as a car accident victim. So just make sure your clients are being very, very, very studious and very careful about who they choose. And I think I just went through all of this. So we've got 2 minutes for questions, and there's one that I'm going to save for the very last. It's our closer question.
Can I just say one, can I say one thing
Yeah.
about Marcy's Law before we go? Marcy's Law is so important, and sometimes, well, in my office, if we can, if we've gotten the case and the criminal case is still going on, we appear pursuant to Marcy's Law. We work with the DA's office. We work with the victims advocates that work for the DA's office. We do whatever we can to help bridge the gap between our clients and what the prosecution team is trying to do. Some DA's offices think it's great and they love it. Others are very skeptical. If you see someone who does a lot of Marcy's Law work and appearances, they're trying to help. So, you know, ask them questions, test them out, don't just let them in. But a lot of us are really doing what we can to help our clients and to help you all and to make your job easier. I think that it's important for every DA's office to know all of the provisions that Marcy's Law provides. A lot of judges don't, even criminal judges who've been on the bench for a really long time. So I just think it's important for all of us to like really steep ourselves in that and to take advantage of that additional support when it's out there and available. So that's my
Power questions. Ready? I'm
yeah.
going to throw them out. This is a hard one. When a person experiences strangulation by a perpetrator and goes to the hospital, and the medical faculty shows evidence a strangulation happened, what's the law in California about strangulation?
It's illegal.
Illegal.
Yeah.
That's an assault.
Yeah.
Um, do civil cases always have to wait? I can't believe we didn't cover this. We were flying. Do civil cases always have to wait for the criminal matter to finish? If
No.
no, why would a civil case get rolling before the criminal matter is resolved?
Sometimes the criminal case is taking so long that the civil victim wants to get started. Sometimes there's concern that evidence is going to be lost, or minds become foggy in terms of what happened. A lot of times, and I've seen this happen, if the civil case is filed first and not stayed, it will put pressure on the defendant to resolve one case versus another. I just saw someone whose name I recognize with a great comment. Sometimes civil attorneys find evidence the criminal investigators do not. Amen, sister. And sometimes on the flip side, well, not really the flip side, but sometimes the criminal defense attorney will get evidence from the civil case and try and use it to their advantage in the criminal case. So that's a downside of what can happen if the civil case continues while the criminal case is still ongoing.
And we've got 2 legislative questions to close us out. Is there any current legislative push in California or federally to expand protections for victim advocates' confidentiality? None that I know of. Not national. It's not a national movement right now. It should
Yeah.
be, but it's not.
And there's nothing in California, but that doesn't mean we can't get people working on it. Get us some language, and I'll see if I can find us a sponsor.
We'll get moving. And then to close us out, I think it's a great closing question. What provisions would we like to change or to see to enhance protections for victims of crime?
The one thing that I would like to see across the board is anyone doing this work for a governmental agency on either side has to undergo trauma-informed education. I think the judges need it. Everyone from, the bailiffs to the DAs to the public defenders. We really need trauma-informed education. I have had judges tell me when witnesses are breaking down on the stand, survivors are breaking down on the stand. Well, cross-examination is tough, Miss Liberty. The survivor is a 12-year-old child. We've got to get everyone on board that we can't be reoffending and abusing in that way.
Yep. We are out of time. As I promised, we covered everything, but we rushed through some of it. As our team is putting in the chat, you will be receiving, and they've put in the chat a few times, if you fill out that form, you will receive a certificate of attendance. We want to thank you all for joining us. We will be sending out an email with Micah's contact information. So anybody in California who'd like to get in touch with her, you are welcome to do so. And this video will be there as well. And thank you all for what you all do for victims every day.
Thank you.
Thanks, everyone.